words proposed to be omitted stand part of the question. I'll call the member for Dunkley.
Thank you, Deputy Speaker. I'm pleased to follow the contribution of the member for Fisher, and I'd like to say that I acknowledge that it was a thoughtful and considered contribution and in many parts set out very clearly why freedom of speech, freedom of thought is very important. There is a but. However, yes, I agree with the member for Fisher. I was doing so well. Look, my only however to that speech is it has to cut both ways. If we are to genuinely support freedom of speech in the way that the member for Fisher and the member for Goldstein put forward in their speeches, then everyone has to accept that people's views that are ideologically or politically different to theirs have the right to be put and to be debated. And to accept the hypocrisy of advocating for freedom of speech for those that you agree with, but not for those that you don't. And the member for Goldstein talked about what he saw as the hypocrisy of the progressive left. And there is no doubt that there are some people who may or may not fall into the description of progressive left, who go a very long way in their desire to stop speech that they see as hurtful or harmful to people in their worlds, and ask for words and phrases not to be used in situations where others believe they have a right to use them. But to suggest that it's only people who are in the progressive left who would like some limits on freedom of speech is in and of itself a hypocritical argument. Freedom of speech does have limits, and I think everyone agrees with that. You know, we teach children that from the day they're born. You might have the right to say things, but you shouldn't be using your freedom of speech in a way that is deliberately harmful or hurtful or offensive. There are limits. And even sometimes if you don't mean harm or offence or hurt, if what you are doing with your speech is causing those things, then there are appropriate limits. And I think that's what many people who, those on the other side, rail against and call cancel culture and progressive left. I think that's what they're actually trying to say is, can you listen to the way in which speech, even traditional forms of speaking, actually are hurting people? And can you put it into the current culture and lives of people and accept that your right to speak that way or use those words causes us hurt and harm, and perhaps not do it? So that was just a little tangent. I thought I might go on after listening to the member for Fisher's speech. What I wanted to do is agree, as everyone on my side and the other side of the chamber has said, that it is uncontroversial that freedom of speech and intellectual experiment and intellectual searching is absolutely fundamental to universities and to education. There is no doubt about that. But one of the issues we have in this country that I think is quite well demonstrated by the different approaches to this legislation and the different speeches that people have given is that we don't have an overarching human rights framework within which to debate and consider the rights and responsibilities of citizens and their relationship with their government. And so we have, since the history of federation, really had a piecemeal and ad hoc legislative approach to rights and freedoms. We have had to have freedoms implied into our Constitution because they're not written there. And that means that when this parliament comes to debate legislation such as this, we don't have a human rights charter or a Bill of Rights, that human rights framework under which to put this legislation. And as a country and as a legislature, we've seen those problems in recent times. Marriage equality, the ongoing discussion about religious freedoms, press and journalistic freedoms that were highlighted last year, or the lack of them, when journalists such as Dan Oakes and Annika Smethurst were subject to AFP raids and very long investigations and the threat of prosecutions for doing their job. Legislation like this, they're all dealt with as if they don't have any connection, as if rights and freedoms don't interact. It's complicated. Human rights law and the approach to rights and freedoms. And we are doing ourselves and the Australian public a disservice by continuing as a parliament to try to deal with these issues one by one. In 2001, in Papers on Parliament number 36, Professor George Williams wrote the following: "A gulf lies between Australians and their government. This stems in part from the long-standing failure to set out the rights and responsibilities of Australians within the political process. The lack of an Australian statement of rights undermines any claim Australia might have to a magnificent human rights record. In any event, the record of human rights abuses ranging from the Stolen Generation to Albert Langer to our treatment of refugees shows clearly otherwise." Professor Williams went on to write, "There is an obvious need for reform. Changes such as improved civics education are important, but we also need to reinvigorate our public life by beginning a process that will involve Australians more directly in the political system. We should draft an Australian Statement of Rights and Freedoms. This should be in the form of a Bill of Rights enacted by Parliament that would offer a coherent domestic means of addressing our many contemporary debates on individual liberty. This could start a long overdue dialogue between Parliament, the courts and the people. We need to legislate for a Bill of Rights now." 20 years later, Professor Williams' words continue to ring true and to resonate. We are one of the few jurisdictions in the Western world who haven't adopted a general Bill of Rights. For some time, Bills of Rights were considered perhaps a European legislative initiative. However, we now look at Canada, New Zealand, the United States has all had a Bill of Rights for a long time, Victoria domestically, Queensland and the ACT. They have developed Bills of Rights. Now, there are a lot of debates about what the exact form of a Bill of Rights might look like and what is effective and what is not. But we're not even having that debate in Australia's federal parliament or politics at the moment, and we should be. The Australian Human Rights Commission has said recently in Australia's third UPR this year, 2021, Australia does not have a Federal Human Rights Act, meaning that many fundamental rights protections are not fully protected in Australia. There are minimal protections in place to ensure that the government considers human rights as part of everyday law and policy making and takes steps to prevent breaches before they occur. There are limited avenues to seek review of government decisions or actions that violate a person's human rights. The Human Rights Commission also says in the same paper that Australia's discrimination laws provide the main vehicle for implementing our human rights obligations. These laws are complex, do not provide comprehensive protection and are largely reactive, placing significant emphasis on individual complaints. There are limited regulatory mechanisms to ensure compliance and promote equality. The Commission considers that an effective anti-discrimination framework should have more emphasis on prevention, measures that will assist duty holders to comply with the law, and more effective enforcement mechanisms when they don't. And government in Australia has been reactive to issues of rights and freedoms for too long, partly because we don't have that national framework of a bill or a charter of human rights. I just want to, before I conclude, return to where I started, which is, in order to stand up and talk about the importance of academic freedom of speech and be taken seriously, it's important that parliamentarians and governments practice what they preach. And as some of my colleagues have already said in this debate, when Senator Birmingham was Minister for Education, he vetoed about $4 million of Australian Research Council grants because he didn't like what they were doing. And universities themselves called that reprehensible, and that it undermined the impartiality of the entire grant process. And listening to the speech that the member for Fisher gave, I can't imagine that he would approve of that either, given his commitment to freedom of inquiry at universities. Former Chief Justice French himself said in the report that from the available evidence, claims of a freedom of speech crisis on Australian campuses are not substantiated. But we know that this government has been doing deals with Pauline Hanson and One Nation in relation to higher education. However, I do accept there are members on that side that have a deep interest in freedom of speech and governments not dictating to civil society what they can and can't say. Nonetheless, this Liberal government has passed legislation which makes it an offence for a Eureka flag to be flown on a building site, or for construction workers and plumbers and electricians to wear their union insignia on building sites. Freedom of speech, freedom of association. We regularly hear outcries about research the government doesn't believe in. We all know, because we all have NGOs and charities in our electorates who are either explicitly or implicitly constrained in the advocacy they are able to undertake because of the funding agreements and the grants from government, from environmental defenders' offices to health providers. These are the sorts of actions from government that don't support the basic rights and freedoms that most people in this chamber have said that they support. So if we're going to talk about freedoms in institutions, we need to be consistent about it. And there is a growing tendency in our political world to label others who say things that one doesn't agree with as un-Australian. Might not agree with changing the date of Australia Day, but surely those who believe in freedom of speech believe in the right of people to stand up and say that they do and why they do. Might not agree with views that people have expressed on Twitter and other places, but the freedom of speech principle that's espoused by those people on the other side who talk about the core values of libertarianism surely says that those people have a right, as long as they're not advocating violence and downthrow of government and criminal offences, to express views that they don't agree with and not be hounded out of the country or called un-Australian or calls for unfunding of broadcasters. So let's have this debate, but let's be honest about the positions that people are taking, and let's try to be consistent when we say that we believe in principles. And one way that, as a parliament, we can bring the Australian people with us and we can bring about some of that consistency is to genuinely start the process of developing and implementing an Australian Bill of Rights.